when a plea deal hinges on a landlord's willingness to accept a payment. The entire legal process can stall over a few missing documents. This hearing in 2026 centered on whether a defendant could get a crucial timeline extension while struggling to meet rental obligations. The judge had to weigh the defendant's financial hardship against the landlord's demand for immediate payment.
88. She hadn't made a payment since last November.
Okay,
Release, may I speak, please?
okay, hold on, let him talk.
You released 9/15, which we haven't gotten yet, but now
Okay.
there's another 9/15 due. So there's currently due 6288.
Okay,
So I tried to talk to her. She got very belligerent. So I'm not gonna speak with her. I would like my, the 56-day rule to be waived. The only reason for the delay has been due to her filing motions. And, we're entitled to possession, and I would like immediate possession.
And Your Honor, I wasn't belligerent. I asked him, I said, he said, did you get the paperwork? I said, I don't know how to respond to that because now if you're not gonna work with me, that means now I need to tell the program, I need help with finding housing. I can't be out on the street. I don't have family. It's me and my son. That's it. His dad does not help it.
so while all of this was going on, you knew there was a high possibility that you weren't gonna have at the time, the $3,000. You didn't pursue a backup plan then as to where you might move or anything?
I mean, I do have a backup plan, but like the lady said, we're gonna help you with the rent. So that's what we.
Who was the lady?
From that program that I was telling you about.
Oh, yeah.
So she was saying, let's tackle this first. And
But that's not,
So
you
that
don't
was it.
follow her direction. You follow what you need to do for yourself, which is pursue that and follow something else in case you have to.
How did you know that they would turn down assistance? I never heard of anywhere turning down a program, giving them a check to pay.
I have, unfortunately.
So I didn't think that.
I between me and you and Mr. Goodstein, I don't understand why landlords don't want the money, but sometimes they say it's too much of a hassle to keep the tenant. So they just rather let it go and get a different tenant and pursue it later.
Be okay once they sent them some type of notice, like, we're about to send you a check. I thought that would be.
Well, they sent who notice of that?
No, I'm saying, I thought once they send it, that
Well, did they send that?
she's working on a thing. She had to review all my documents because I showed her my check stubs and.
So you don't even really know if you're gonna even get it.
No, I'm approved. It's a process. She has to still go through all my documentation. And I guess they gotta see exactly the dollar amount that they can help with. So I had to show her all of my laid off documentation from unemployment.
Mm-hmm.
She even told me put hospital and doctor documents in there from when my son has been sick over the time within the last couple months and everything, and they calculated. But I'm approved to get assistance, but she's working on everything. She said no later than the 10th, she would have a amount and they would be ready to send it out.
Mhm.
So I don't know. I just was asking him for some more time. He seems to not want to work with me. So I'm asking, can I at least get a few weeks to find relocation? Because now I need to call the lady, tell her they're not going to accept the assistance. Can you help me get placed into something else? Because it's programs that help you get placed elsewhere. So I just thought that they would work with me, being that I paid the escrow, being that, I've been in communication about everything. I thought they would work with me. So I didn't know that this was going to be the outcome today or last week either.
Okay. All right.
Your Honor, we haven't gotten a payment since November,
You did. You just got the
which
900.
we haven't gotten yet, but that, I was just gonna say, except for 9/15. She's made repeated promises. There's even 2 letters in the court file that she needed 2 weeks to get her tax return and she was gonna pay it. She hasn't kept any of her promises. We have no confidence that she's gonna make any payment. She hasn't come up with any definite payment plan. She keeps saying, I'll pay extra, $500 extra a month. That would take her 6 months to a year to catch it up.
Yeah, about a year if she was paying on 62,
That's just unacceptable.
6288 at 500 a month. But she says she's getting,
I'm not sure if they're familiar with billing. I get 37.41. So that's how much I'm being paid. And working 9 hours a day, and sometimes on Saturdays, I get a lot of overtime coming in soon.
okay.
Because now they got this new car coming out. They's not gonna take me that.
You have a new car.
They have a car that we about to retool for. So I mean, I don't know. I don't know how to prove that I could pay it down and I'm willing to pay it down, but
Did you bring a paycheck stub since you've been back to work? You have one?
On my check stub, though.
You could pull it up.
Print it out because I don't have a printer.
But can you pull it up now? Because at least that shows she's got some income coming,
Yep.
which she didn't have before.
Shut it from, see, he's sending them to the program.
Let's see if that
Your Honor,
makes a
briefly in
difference.
response, she hasn't said she hasn't made any statements that would be, contrary to me being allowed to have the 56-day rule be waived. The only reason the time's gone by again is because of her actions, not ours. I would say the same thing that I
Give it to
said
him.
last. She should come up with as much money as she can. Go in and see the manager and see.
Well, the manager has told her she can't do anything.
She's telling me that she.
Well, she hasn't come up with any money. She just goes in.
She says she's not the person to work out any payment plan with, which I've never heard of that, but maybe that's true.
They mail your rent to them. It's not even a corporate that you.
This says net pay 25,160 year to date.
From
If you made,
January to now.
and you paid nothing in rent. Why didn't you pay any rent?
It was an unemployment, sir. I've been getting 500 a week under unemployment. Would you
Okay,
like to see my document?
Your Honor, maybe you can make something of this. I can't really tell anything from this.
Is that a paycheck stub?
No,
Yes, there's a paycheck stub. It says e-pay.
it says FCA. So how much are you making? Where's
37.41, it should be right here. 37.41.
$37.41, it says is your pay rate.
Yeah. And
That must be per hour.
It's hourly probably.
But that doesn't tell me how much she's getting a week, how long she's gotten it, and if she's
How
getting.
many hours do you work a week?
Well, we work about 35 hours.
$31 and what?
$37.41.
37.41 times. Now you stuck here, you can't work, you can't go to Stellana's. 37.41 times, how many hours a week? 40 what, 45?
Sometimes 45 if we do the 9 hours a day.
Sometimes.
Yes.
So that's 1683.45.
You might work 8, and then Tuesday you might work 9, Thursday you might work 9, every day you might not work 9.
So it's approximately 1683.45 for that week. If she's making 45 hours. Uh-huh.
And then I also got my documentation from me being on unemployment up until April. So.
Your Honor, again, we're getting nothing but, she speaks in generalities and we never get a payment. Nothing comes in.
I haven't spoken to you since back in February when I was laid off.
Well, I don't really know how she can prove she's got a job. Now, I don't, if you give her a payment plan and she doesn't make the first payment, well, then that's it.
And that's what I'm.
We can wait 56 days, allow you to proceed on a writ if she fails to make the first payment on whatever you guys agreed
We
to.
don't want a payment plan. We're done dealing with this woman.
They never did a payment plan, so how can you say we don't want to? My
We've delayed.
very first court hearing was in February. He told me at the table, we don't do payment plans. I said, well, I'm falling behind because I'm laid off.
Well,
I brought him the paperwork.
why don't you just go get a better landlord then?
I mean.
Somebody that will work with you. And there are places that will work with you better than this. That's all I can tell you.
But that's what I'm saying. I have to find something out. That means I have to apply for somewhere. I gotta show them my check stub. My 9/15 going to them, so it's not like I even have nothing to start with until Friday when I get paid. To even say, this is my down payment for the.
How much time do you need to get ready to move? Cause I'm gonna give you some time.
Maybe about let's say probably a couple weeks. I need to call them and tell them now I need help with finding somewhere to relocate. Because yeah, this probably not the best for me. I just, when you get used to staying somewhere, you don't want to go through all the moving.
I fully understand that part.
This was a consent judgment back in February.
Because I was sure that I was getting my taxes until they sent me a check stub of $76 saying that we miscalculated. And I also had those documents. So I'm still fighting with IRS right now to see why do you figure that?
Okay, so this is what I'm gonna do. I'll grant the motion to waive the 56-day rule. Writ of eviction can't issue, and I'm gonna give you or be executed. If we need a new one, we can get a new one, but
Want a new writ?
I would think you need one. We
I
can-
would just put it in the order, written, executed.
Right, 56-day rule has been waived after hearing. And 1, 2. Can you be out by June 26th?
Sure.
That's almost 1, 2, 3 weeks and some days.
Yeah, I'm sure we get another.
Okay, that's a Friday. Okay, so that's what we're gonna do. I'll make a note of it.
So don't need no more payments to that, correct?
You tell you what to do. I'm not your lawyer.
Well, no, I'm just saying, so. But they-
Put it this way, you're gonna end up owing the money anyway because they could sue you later for it. They just don't have a judgment right now for it. So it's up to you to determine if you're gonna pay the rent, which you know you've lived there. So you know it's part of your contract.
Yeah.
So,
That's
you,
why I'm trying to just stay. You don't want me to stay.
Well, you know, listen, now that they got the writ, you never know. Things could change. I don't know. But right now, you gotta make it, if you want them to change, you gotta at least look like you're getting ready to pay what you buy. But you're asking me now, should you stop? I'm telling you, you still owe.
With them and
Ma'am, I'm telling you, do you listen at all?
Yeah.
You still owe.
Right.
So you should pay something if you can.
So keep paying and trying to move. That's what I'm saying. They put me in a tight spot because how can I
Well,
move here and there?
Well,
That's my thing. That's why I prefer to pay to them and stay. That would have been the easier route. for me
Ma'am,
to
if you
stay
come up with
to
a substantial payment, like $5,000, go in and see the manager and they might work with you.
$5,000 at once. Like,
All right, then move.
mhm.
Your Honor, did you sign the order releasing the escrow? I filed it last week.
yeah, my cues are clear. At least as of last night they were. Yeah, I've signed everything.
Okay. So I'll file another order waiving the 56-day rule.
Right,
And
after
writ
hearing.
issue after June, on June.
Make sure you make a note that we had a hearing on it. And writ to evict may be executed after June 26th. All right, so there we're all set.
Thank you, Judge.
Good luck, ma'am. Beautiful police. Mhm.
Judge, we're ready on the motion for consent.
Well, let me see.
Judge Nickel. So
It must be. It's not really a motion to compel.
So you know what?
I don't know what they called it that for. Is it a caution?
Yes.
Oh, yeah, whatever did it.
For out service on somebody, a third party. 377. This is case number 2600377 GC Care PT versus Allstate Insurance Company.
Good morning, Your Honor. Phil Arab on behalf of plaintiff, case number 86220.
Good morning, Your Honor. Gina Smith-Gallant on behalf of Allstate.
All right, good morning to both counsel. And we are here today on behalf of Allstate for a motion for alternate service for a deposition on Mr. Harrell, who I guess is the injured party here. Okay.
Yes,
We're not
Did you
posting the
parties talk about
motion.
this? Did you
Yeah.
talk about it?
Hold on.
That
Yes,
was just
I
asking.
don't think there's opposition,
Okay,
right?
No,
Am I
there's not.
correct? Yeah. So,
all right.
okay,
Well-
sorry about that. Yeah, we went to case eval and we talked about a couple of things, but we need to know, this guy was in and out of jail, and thank you, counselor, for not opposing, but I just learned of the confirmation of that today.
Well, hopefully you have a correct address for him. Huh.
Yes.
Because that's the note I have here says that somebody said that he moved, and then somebody else said that he lives in Dallas.
Yeah, that's the address, Dallas. So we had an investigator go out. So it looks like that is the last known, and the person there knows him. So
Okay.
We tried at some other places as well, but we're gonna try to do it there.
All right, well, hopefully this gives you the information you need to decide the claim here. All right, so we'll
Yes.
go ahead and grant the motion for alt service of the deposition for Mr. Ronald Harrell. And
Okay.
Ms. Smith Gallant, if you would like to prepare that order for us.
Yes, I would. Thank you so much, Your Honor.
Thank
Okay,
you, Your
you're
Honor.
welcome.
Have a great day, everybody.
All right, good
You
to see you
too.
both. All
You
right.
too. Thank you.
Now, let's see. Okay.
This exchange shows the tension between a defendant's financial excuses and a landlord's need for security. The judge has to balance the need for due process against the risk of homelessness. When a court grants a motion to waive a deadline, it's essentially recognizing that the delay was caused by circumstances outside the defendant's control, which is a necessary step in equitable relief.
You want me to keep this or toss it?
Okay. All right. Okay. She said we're ready. We got it. Case number 26S00261 SM. People Center, Michigan versus Latory Dudley.
Your Honor, Courtney Rose on behalf of the people.
Good morning, Your Honor. Sultan Steve on behalf of my clients. That's Dudley. If you state your name for the record, please.
Let's already do it.
Okay, Ms. Dudley, we're here for a scheduled bond violation hearing on the domestic violence second offense. Let's see what's going on here. Got lots of GPS tether reports, so let's just see. Looks like I said set a hearing from a report that was dated May 15th that defendant was in violation of the bond conditions for tether due to entering an exclusion zone. She was in and out real quick though at 10:48 and 10:48. They called her about it. She passed through it while traveling north on Telegraph. She didn't make any stops. She was in there for less than a minute. Let's see what we've had as a follow-up though. May 22nd, she was alleged to be in violation due to battery shutdown and tracking was not available. And it went down at 2:24 p.m. and was not yet restored. And that was on May 21st. And so it wasn't restored on May 22nd when they wrote this report. Home confinement contacted her, told her to charge the device immediately. She said she would, claimed to have been charging at the time of the call. They requested a welfare check be sent to the alleged victim. They did send a follow-up to pretrial services at 3:24 stating that she reported she tried to charge it, but it was not charging. They advised her she'd need to meet a technician to have it inspected and or obtain a new charger. She said she couldn't do it. She had to pick up her kids from the bus stop. She was given the option to obtain the charger at the office after hours, and she declined to do so. Pretrial services contacted her regarding this. Same day on May 21st, left a voicemail. She left a voicemail to pretrial services saying she was in contact with the tether company and was unable to report to them on 5/21. They sent her a text message saying she needed to charge it. She last charged the device on May 20th at 1:36 a.m. So this was a May 22nd report. She still hadn't charged. And then here's like a little charging cycle update for her device. And it shows the last charge, May 20th, 1:36 a.m. Then we have another report. You can have that if that's a duplicate. This other report's from May 26th. Update. The tether charged at 3:31 p.m. on 5/22 at home. Your battery was shut down for a day, 1 hour and 8 minutes. And basically it's the same as the 5/22 report. just added that it finally came back on a day and an hour or so later. So those are the violations. Going through the exclusions though, having a battery shut down that she did not immediately rectify. How would she like to proceed on the bond allegation?
Like to admit to plead guilty to a bond violation with an explanation.
Is that right, ma'am?
Yes.
All right, anybody force or threaten you to make you give up your right to have a full hearing?
No.
Anybody promise you anything to make you give up your right to the hearing? You're doing so freely and voluntarily?
Yes.
So it's true that you did drive through the exclusion zone, by being on Telegraph Road for about a minute in and out back on, May 14th?
Yeah, I was on, yeah, I was on my way to the, bank and, I was, in a lift, I was riding the lift and then we had passed it, so, yeah. And I didn't know, I didn't have a idea of a bus, the lift driver going that way, so, yeah.
Okay. And
That's what happened, yeah, that's true.
is it also true that you had a battery shutdown?
Yeah, I had battery shutdown because,
I just want to know if you had a battery shutdown on May 21st that you
oh, yes.
did not rectify till 1 day and 1 hour and 8 minutes later.
Yeah,
That's sufficient enough, I believe, for a bond violation, and I'm going to accept her plea to it, finding that it is freely, voluntarily, accurately, and knowingly made. Okay, let's see. All right, Mr. Rashid, what's the situation with the battery shutdown?
With the battery shut down, it was just an issue with the charging. She didn't realize that she needed to charge it at both night and day for 1 hour. She was just charging it at night. And in the beginning of the process, it was working, it was charging for the full day. However, it just didn't charge. And EMS or the tele company called her, let her know the issue.
I told her to come right away and she didn't.
Yeah,
Then they said, we'll come after hours, and she didn't. Why is that?
well, she had her kids on that. She had to pick up her
What's
kids.
she gonna do with them when she in jail?
Right. It is something that she should have handled immediately.
I don't play with no tethers. I don't care what your excuse is, what you got to do. Nothing for me is more important than complying with the tether. For you, you should be saying the same thing. You should have gotten over there. If it was something wrong with it, they would have fixed it right away. If it was your error and not charging it morning and evening, that's your error. But you should have gone over there and had them look at it and not waited over a day later. Are you kidding me? You waited that long.
no, I don't have transportation, I had to that's the problem, I don't have transportation. I had to end up, catching a lift, and then both of my kids, they are disabled, so they get dropped off in front of the, house. So that's why I couldn't, go at that time.
Okay, but they said they would wait for you later after hours. And you
I
didn't
know,
get
but
them.
I was gonna have to, I would have to took both of my kids.
Well, that's what you and my mom had to do.
Yeah. So that's why I waited until they went to school, and then I went the next day and I had got a new charger.
Okay, now do we see the error of our ways there?
Excuse me?
Do we see the error of our ways? Yes, you did what was more convenient for you, but that was not what you should have done for the court. You should have gotten over there, and if you had to take them, you had to take them. See, this is what happens when you get involved in the criminal justice system on a second offense domestic violence. We somewhat take over your life, which means you don't get to do the things that you were normally doing the way you would normally do them. You have lost the luxury of saying, well, I got to go over here with the kids, so I can't do that. We're telling you, you have to do that or you're not going to be with the kids. So you've got to figure out how to balance that. You see what I'm saying? I'm not saying it's easy, especially if you have special needs children. But if you got any help at all, you need to call in the cavalry and say, hey, can you come over here and get the kids or sit with the kids or give me a ride or whatever, just this one time? You got to have a girlfriend somewhere. Not one.
No, I don't have friends. No.
Okay, well, no man can live alone. You got to have a person, at least one. Else you gonna stress yourself out, because if you don't have anyone that you can call a friend, depend on, I'm not saying you can have a ton of them, just one that cares about you enough to say, yeah, I'll come over there for a couple minutes. I'll get you somewhere. It's not like you're asking every day. If you don't have that, you're gonna stress yourself out. And you young now. You can't do that forever. And if you got special needs kids, you got them for the long haul. They'll be grown adults and you'll still have them. And you're gonna worry yourself out. And then when you're gone, you don't have any friends or relatives. I don't know what happens to them then if you haven't made plans for them as adults. So you got to start looking at the bigger picture and not just little incident to incident. But for me, this is serious. And I don't even know how you got yourself into these charges or the charge before it makes it a second offense.
So it's problem.
Yeah, wasn't worth arguing with him like this.
That's why I'm in the system. I'm dealing with this now because of him.
Yep, because of him and the way you reacted to him. He ain't worth that. You put yourself in the system and he walking around doing what he doing. He not in the system, at least not for this. So you got to start to think things through, Miss Dudley. Because this is a huge thing. This teller violation is huge. Because in a domestic situation, and I'm not what the person might do to the alleged victim. People do get killed in these situations. Starts off with something small. Those go over there anyway. But we got a tether. We don't know where you are. That's huge red flags. Alarms go off.
And then I end up getting my own place, so I have my own place now. So
Okay, well that's good. You're not. But yeah, that's good. But you can't do this anymore. People wish to be heard at all.
no, yeah.
Oh, boy. Okay. I gotta have an understanding with that she understands how important the tether is. This is the second offense, domestic violence. She's looking at over a year in jail if she keeps messing this up. Nobody wants to do that. All we want to do is get her mind right, get her rehabilitated, get her to see that she can't let people push her buttons to this kind of an extent, especially the father who knows you well enough to push every button you got. You got to get it under control and rehabilitate you, not per se lock you up for it, unless you did something really horrible to this guy. But you're pushing me by failing to comply the way you got to. So we got to come to an understanding that you will do 1,000% to try to comply with this, no matter what's going on. Now, hopefully you don't have another battery shut down, but they can happen. Something could go wrong with the machine. Not saying that part is your fault, but you got to do what you got to do. And from what he's saying, you got to know you got to charge it twice a day now, too.
She's learned from this experience. She understands how important it is to comply with the tether. Just it was just very challenging for her with her kids getting out and balancing those expectations.
I understand that, but we just had a conversation about that. If she's in jail because she's violated the tether, she can't help her children. She's got to take care of herself, her business first. And that's the goal. I mean, that's the lesson to learn. And that's for sentencing. Okay, we should.
Well, Your Honor. Thank you.
Mhm. Okay. You ready on that, Karen?
Ready.
Case number 24L00237FY. This is People of the State of Michigan versus Jeffrey Martin.
Morning, Your Honor, Courtney Rochelle on behalf of the people.
Good morning, Your Honor. Good morning to your staff. May it please the Honorable Court. My name is Russell Perkins, P55.
When the court grants the motion to waive the 56-day rule, it is allowing the defendant more time to secure new housing without immediate eviction proceedings. This shows the court exercising discretion to prevent a harsh outcome when the defendant has demonstrated good faith efforts toward resolving the debt, even if those efforts were slow.
623, appearing on behalf of Mr. Martin. Mr. Martin, can you state your name today? I didn't hear you, sir.
Sir, you gotta speak up like it's not like I'm talking, but it's you.
Yes.
Okay. All right, so when we last here, this matter was, we'll start from the beginning. We have a carrying a concealed weapon, a reckless driving charge, and a violation of restricted license charge, which we had sent the defendant for forensic examinations. We've had a couple of hearings, between experts regarding competency. The last time we were here was May 11th. At least the prosecutor and I were here. I didn't bench warrant the defendant.
We were on Zoom. I thought it was on Zoom.
You were not here. You were in Iowa.
Yeah, it was on Zoom and I had.
And it was unclear if he gave you notice. So I didn't bench warrant your client.
Okay.
I did say I had the independent evaluation of the disputed competency hearing today. And is that it? Yeah, from Premium Psychological Services, LLC. Yeah, which we got Vic at 5'5", we got at 5'11". And basically it's from Dr. Demetrius Ford, who says in conclusion, he didn't think Mr. Martin was competent to stand trial. He gave his reasons, fairly lengthy report of approximately 7-8 pages here. Yeah, 7 pages. All right, so we set it for today for a hearing on this.
I have Dr. Ford present. If the court questions from him other than his report. But if I may just jump right in, Your Honor.
I mean, I got people from the forensic center saying one thing. I got Dr. Ford saying this. So I don't see how I can't have argument. I haven't heard any testimony from anybody on these.
Well, I would say this, is that once you found him incompetent, the forensic center has not seen him, has not provided any services other than the one time that report is a different expert or a different proposed expert. I think the social worker who saw him in April or March of this year, but they really just stand on a position that without having provided any services, without him having been treated, that he's not competent with. Very.
Bring a witness in and have some testimony about what they.
That's what we're here for,
Okay. All right,
because we can just argue it, but it is what it is.
that's fine.
And we need some testimony so we understand why they said what they said and what they did, so I can make a determination.
Okay.
Okay, and which report for the front, was that the April 15th, 2026 report from no, it's from Andrea Vandenberg. Well, no, that's the cover report. Yeah, cover report was from Ms. Vandenberg. The actual report was from.
The judge's intense focus on the defendant's excuses highlights the seriousness of protective orders. When a defendant violates a court-ordered restriction, the court views it as a direct threat to the protected party, regardless of the defendant's claimed intent or hardship. This strict enforcement is necessary because, as established under MCL 777.1 et seq., courts must balance individual hardship against public safety mandates.
Morgan DeLeonard, clinical social worker. Okay.
I'm looking at one thing. Oh, no, I'm, okay.
Ms. Vandenberg wrote a cover letter from April 15th about the report. She's a hospital.
Let me see.
In the hallway and get my witness, yeah.
Yeah, go ahead. April 15th,
26 or 20.
26.
I don't think I.
We received it on April 1st and it dated April 15th. So we got it by fax.
Yeah. I'm sure I've got it. Can I get it?
You want a copy?
Please, can I get one?
Did you get him a copy? And I'll take just a brief recess.
Just like that.
Okay, we're back. The court is back in session. Sheila R. Johnson presiding.
Okay, you may be seated. Versus Jeffrey Martin, 24L00237FY. All right, so when we last took her little recess, prosecutor was going to get her witness. So you ready?
Yes, John.
All right, go right ahead, call your witness, and raise your right hand. You solemnly swear or affirm that the testimony.
Introduce yourself to the court and describe your current position.
Hey, yeah, my name is Morgan DeLeonard. I'm a licensed master social worker and I work at the Center for Forensic Psychiatry and
The Center for Forensic Psychology or Psychiatry.
yeah, it's confusing. So basically two sides. There's an evaluation services side and a treatment services side, where patient goals, primarily around competency restoration treatment. Getting them.
Thank you. Would you please describe your educational, what was your bachelor's degree in?
Also in social work,
And your master's was in social work?
obtaining a specific amount of clinical
What does your clinical social work license allow you to do in the forensic mental health setting?
So in the forensic mental health setting, my license allows me to basis. So when I was hired into the forensic center, I was primarily on the inpatient side of things. I was doing things, I was running groups for group therapy. I was doing individual therapy, writing court reports, and also obtaining my forensic certification around that time as well.
So you are a certified forensic examiner?
Yes, I became a certified forensic examiner. I completed my training in April of 2018.
What types of evaluations do you conduct in your position?
I'm able to do competency evaluations, right? So those sometimes include initial competency evaluations, and like in today's case, they it's incompetent to stand trial.
And you mentioned some training. What training do you have that helps you to conduct those evaluations?
Sure. So like I mentioned, when I was hired at social work, but then I became years worth of various didactic courses where we're learning about the competency process, the statute, you know, the things that go into the statute, how to write the reports, didactics on a variety of different mental health concerns. And then also in that process, there's a number of cases that we have to observe other forensic examiners to complete those cases. And then we're also observed for a certain number of cases. And then at the culmination of all of that, we have a mock trial. Includes your certification.
And how long have you worked at the Center for Forensic Psychiatry?
About 9.5 years. It'll be 10 years this December.
I'm holding in my hand what I'll mark as People's Proposed Exhibit 1. Showing defense counsel. Yes. May I put you?
Yeah.
Mr. Leonard, please tell the board what I've needed you.
This is a copy of my CD and also a report on like total number of cases. So it's titled "My Opinions Issued During a Big Rain."
Okay, it's a 2-page document.
Yes.
I move to admit this as People's Exhibit 1.
It's her CV and what else? Did you say what?
So there's a report, just it goes over the number of opinions that I've officially submitted for competency related matters.
Okay.
And it's dated January 1st of 17 through November 4th, 25. I was explaining prior to this that our database recently changed, so.
November what of 25?
November 4th of 25.
Okay.
So that addendum is sort of an overview of your general statistics.
Yeah, so yes, so it's it was a database that we utilize at the center to just, to compile data for ourselves, right? So we know the number of cases we've seen, types of opinions we've rendered.
Okay. Any objection to
To the report, no.
exhibit A? Exhibit 1, I should say.
Exhibit A or one?
It's 1. That's admitted.
Thank you, Your Honor. Just briefly, what was your work at the center from 2016?
Mostly due to clinical social work as I was obtaining that forensic certification. So primarily my job from 2016 to about halfway through 2021 was working on an all-male admission unit at the CFP. I ran a variety of therapeutic groups and also did individual counseling with the disciplinary treatment team, creating individual plans of service for each patient that I worked with. So just more treatment, more clinical.
And what has been your primary role at the center from 2021 until the present time?
Sure. So in 2021, as you're all probably aware, we found ourselves at the center needing more full-time forensic. Our long wait lists, right? We wanted to make sure that we're addressing that. So over to full-time evaluation services. So at that time, I was actually promoted full-time examiner, essentially. So I no longer work on the inpatient.
And so all of your work now involves competency evaluation?
So we're going through that forensic certification. So it's primarily, yeah, seeing patient or seeing defendants throughout the week. And then also just some other responsibilities within my department.
Approximately how many people have you trained?
Maybe 20. We're involved in their trainings of new social work staff at the center.
Please describe the types of defendants that you evaluate in your role.
Are you speaking to like their mental conditions or?
Yeah, just the types of evaluations, what you're seeing.
Sure. So I am seeing a mix of facing criminal matters. I'm seeing them on that initial order for competency evaluation, where we may or may not have any prior history on that person. It's a new legal matter. It's a new question of competency. And then the other type of case that I see quite often are these restoration to competency or reevaluations, excuse me, of competency for folks who've already been adjudicated IST, and where we're getting that like a 90-day progress review of how that person's doing.
Do you have experience with individuals that experience severe and persistent mental illness?
Yes.
How about individuals with intellectual disabilities? Who may be in psychiatric crisis?
Yes.
And that addendum that we briefly discussed, would you just describe what
Opinions essentially for the entire period that I've worked at the Forensic Center, right through essentially what this goes over is that, you know, since starting at the Forensic Center through November of last year, I've submitted approximately 670 at that time opinions to the court, meaning that I've completed, you know, close to 700 competency evaluation reports for those initial competency evaluations. The sheet also breaks down the types of opinions that were offered. So there's this where it says where it says A, to us that means an initial competency evaluation.
Okay.
And then it breaks down my opinions by type, right? So approximately 59% of the time. And then I found folks incompetent to stand trial, approximately 40.
whether competency has been restored?
Sure, yes. So for those reevaluations, as of the date of this report, I had performed, or I'd submitted 358 of those opinions. So that means I've done that many, 358 of those evaluations and submitted reports for that. And in that case, the opinion breakdown was essentially 75% of that time. I found that folks were still incompetent to stand trial at that 90-day progress review point. And about 25% of that time, I found that they were no longer incompetent to stand trial.
Okay, so the gross majority of your opinions in this sort of situation is that you're finding defendants are still incompetent.
Correct.
So is your role to advocate for either side or to give the court a neutral opinion?
Oh, no, neutral opinion.
Your Honor, based on the test, well, first may I publish People's Exhibit 1?
Yes, please.
Based on the testimony of Mr. Leonard so far, I'm asking the court to recognize her as an expert in the field of forensic mental health evaluation and competency to stand trial assessment.
Forensic mental health evaluation. Is that what you said?
Yes, ma'am.
And what was the rest of it?
Competency to stand trial assessment.
Okay. I guess, is there any Mr. Parker?
Well, I couldn't hear you.
Any objections? Sure.
Good morning, Ms. DeMinner. Good morning. Now, you've indicated that the forensic center, you said, is there's two sides. There's the evaluation side, and then there's the treatment side, correct?
Correct.
Is the treatment side all inpatient, or is it any outpatient with that?
All inpatient.
Okay. Social work, but that in and of itself does not allow you. Is that fair? Just the,
No, not
Just-
just the master's degree, no.
correct, okay. Now, the training that you described that you've had, to be a certified forensic examiner occurred since you. Purpose, we're gonna for forensic psychiatry.
We just say see it,
Yeah.
forensic center. Uh, repeat that, I'm sorry.
Yes,
Um,
the training that you. CFP.
For some of your boss, you'll sometimes request a psychological.
In the training as of, that you receive.
Sure.
What were you speaking about with that?
So really this, for the first year, essentially with folks that are in that, training process, right? And this included folks from each discipline too. So the newer social workers were also with newer psychologists and newer.
Stop you 1 second. You said something that's as far as disciplines. I'm only for the purpose of record. You've indicated 3 disciplines, 1 social work, 1 psychology, and then psychiatry.
Correct.
Those are the 3 disciplines that are in the umbrella of the CFP?
So, well, for the purpose of, for evaluations, yeah, for the purpose of performing those evaluations,
Okay.
yes. That's
All right. Okay.
So I say that to mention, or to say that that group of folks essentially would go to these different classes or trainings a few times a month, right? So there would be trainings on how to write a forensic report, or looking at various case examples. There were trainings on different mental health conditions. And also during that time, in addition to those didactic trainings, I'm also working on that inpatient unit for folks who have already been found incompetent to stand trial. So I'm also working with those folks, sitting on that treatment team, discussing their progress, right? And getting that experience about, of treatment for somebody who has been deemed incompetent to stand trial already,
Okay.
and assessing their mental conditions.
Now, with respect to the, you indicated you've been doing, forensic examinations or forensic mental health evaluations for how long?
So I became certified in April of 2018. However, because I was doing my training, I was also doing cases under the supervision of other examiners in that, because the report that I provided, yes, is from January 1st of 2017, right? So there were few evaluations that were completed prior to the supervision of either a consulting forensic examiner or a certified forensic examiner.
Okay. Now, you indicate.
When the defense raises questions about expert reports, they are challenging the reliability of the evidence presented to the court. The right to an impartial hearing is protected by the Sixth Amendment, which guarantees effective assistance of counsel at all critical stages of a case. This means the defense must ensure that every expert opinion is thoroughly examined before the judge makes a decision about the defendant's ability to proceed.
Do you have any form of peer review?
What do you mean by that?
And in the performance of what the services that you provide to the people that come to the CFP, are you subjected to any peer review by the supervisors or someone who is of a,
Sure.
I won't say greater discipline, but perhaps are you a psychologist or psychiatrist? Are you any peer review by some cross-section of the disciplines?
So there's regular monitoring in place, I should say, for any examiner at the forensic center where management level folks from social work, psychology, and psychiatry, depending on, they will pull reports on a random basis to audit them essentially, right? Just to give feedback about, the quality of the report or, standards or procedures that you went through. But yeah, there's an auditing process that they will do without pause. It's randomly.
That's a random or is it a regular process?
It's regular and random. So they're doing it regularly, right? And the reports that are pulled are randomly pulled. Sometimes there will be for cause audits, right? So if there was a concern brought up about a specific report that was brought to management, they would of course look at that. But for the most part, management is just.
An opinions issued for a range of time from January 1 of 17 to November 4th of 25. And it totals, these are the totals that you have done, or it's almost like a stat sheet.
Exactly, yeah.
Okay, so in that first column, you have 298 competency opinions.
Can I look at?
Yeah, absolutely. Would that refresh your memory?
Yeah,
Okay. Yes. Please, let's-
I think that's what it said, yes.
Okay, well, I guess my question is, yeah, if you could give it to us,
Yeah,
I did have, it is on a map.
Is this what it looks like?
Yes.
Yes, that's, so on there, it indicates. So 298 total competency opinions, is that would be accurate?
For initial competency evaluations,
Okay.
for that order type, yep.
Okay, so now when I'm down here below and it says 358, it says IST progress report opinions. That's a different section of people.
So for initial evaluations, that would be a brand new referral, right? So that would be somebody who there's been no, the order that we would have received would have been that order for an evaluation of competency, to stand trial for those 90-day, for the section you just referred to, where it says IST progress report opinions. Those are for folks where the court order is the finding an order on competency. So where, like in this example, where
The process of qualifying an expert witness like Ms. DeLuna is crucial because the court must be certain their testimony is reliable. Because her opinions are central to the defendant's ability to face trial, the opposing side rigorously questions her training and oversight. This vetting process ensures the jury hears expert analysis grounded in accepted professional standards.
Judge Johnson would have signed off and said, yes, this person is, incompetent to stand trial.
Okay.
So that second section is for folks who have already been deemed incompetent to stand trial. Yes.
I guess the totality of the question is, those are just not simple math. Like everyone in that first section where it says competency opinions A are not the same as they're not necessarily the same, or there could be overlap between those two categories. Is that fair?
Sure. Yeah, there can absolutely be some overlap because, we're using the same standard essentially, right? There's still the same statute on competency. So the opinion is still being based off this statute. And there's a difference in that there's one group who have no opinion submitted, right? And nothing's been adjudicated with the court yet. And then the other group of folks where they've already been deemed incompetent to stand trial.
Okay. Is there any, with respect to the training that you received, what barometer or what standard is used to determine that you've risen to the level of sufficiency to become or to perform the duties that you've been called to do?
Sure. So our training is based on, there is some language in the Michigan administrative rules, to my understanding, about the number of evaluations that you have to perform under observation. and the number of evaluations that you observe. And then I guess who's making that standard would be the administration at Forensic Center. I mean, that's my understanding of who's making the specific training, curriculum, I guess is the way to say it. But yeah, it's based on administration's interpretation, I guess, or application of the Michigan administrative rules and what those administrative rules say about the requirements for becoming a certified forensic examiner.
Okay, so there's no standardized test that anyone takes to be declared a certified forensic examiner. It's more the administration at the CFD that determines you've attained a certain amount of training. Now you can do the work.
Right, so there's no formal like written standardized test. I would say that the testing process essentially culminates that training. It would be that mock trial that we complete at the end of our training, which is where we would take one of the cases that we had done under observation and essentially practice this. So
Let me ask you, you've been a part of the mock trial, I'm assuming back in either 2017 or 2018.
18.
You have witnessed and seen those trials being conducted throughout the years since you've been there, is that fair?
Correct.
During your year, was anybody not approved?
Not that I know of, no.
Okay, was anyone not approved in the following years? Do you recall any others? And I'm not necessarily calling out names, but.
I can think of a very small number of staff who were not moved to complete their forensic training, right? So they were not offered an opportunity to complete that mock trial for whatever reason.
Okay, you don't know the reason, but. Well,
No, that would be a management, that would be a management.
That's a higher up decision.
That's cool.
But those are individuals that didn't take the mock trial. What I'm saying, anyone who took the mock trial, those are individuals who took the mock trial. You don't know of anyone who was not told to do or that they couldn't perform the work that you do.
Correct, not to my knowledge, but again, I'm not management, so I don't.
Fair enough.
Yeah.
Only to your knowledge. That's
Only to my knowledge, and I don't attend every mock trial.
fair enough. I don't have anything further to add.
Any objection then for this witness to be qualified as an expert in forensic mental health evaluations and competency to stand trial assessments?
For the purpose of this hearing, I do not.
Okay, so then the court's gonna make the finding that apparently she would be considered to be an expert. I think that she does give sufficient information to provide some guidance in an area where the court certainly is not proficient in. So she would help the person weighing the evidence to be able to come to some determination as to evaluating what the evidence would be. And apparently she's sufficiently trained with sufficient data and information that the court would be able to rely on to some extent, whatever she is saying. And so I do believe that she would assist the fact finder here as to methodologies and protocols that are used in this field. So I'm gonna definitely deem her an expert.
Thank you, Your Honor. Mr. Leonard, what is your understanding of the legal question the court must answer in a competency proceeding such as this one?
Sure, so my understanding of that statute for competency to stand trial is essentially looking at two different prongs, right? So when assessing somebody for competency to stand trial, we're essentially looking at, is this person able to rationally assist counsel? Meaning that, is their thinking, based in reality? Are they able to have a rational and reciprocal conversation about things? And then we're also looking at, does the defendant understand the nature and object of the proceedings currently held against them? So that speaks more to their knowledge of the court system, their understanding of the current charges, or the current proceedings that they're facing.
Okay. How is competency different than a mental health diagnosis?
Sure. So those are very different things, right? So, so for a mental health diagnosis, I guess the way that I think about it is And this is probably just from years in the social work field, right? So I think about social security disability applications sometimes when I think about this, right? So I think about, it's one thing to have a diagnosis, right? You can have a medical condition, you can have a mental health condition, and there's functioning on the other hand of it, right? Which is, does that mental health or medical condition rise to the level of impeding somebody's functioning with whatever the question is, right? So the difference, I guess, in terms of that would be that, you know, folks can have a mental health diagnosis, and still function fairly well. A mental health diagnosis also, in my opinion, right, requires time. It requires, you know, a different type of assessment when you're meeting with that person. And I think that is very much based individually, right? So if I'm working with somebody in a clinical sense, right, and trying to determine whether or not there's a diagnosis there, I'm looking at different criteria, right? So if I'm suspicious of, you know, a diagnosis of like major depressive disorder, for example, I'm going to be referring to the Diagnostic Statistical Manual, the DSM, right, to see if that person is meeting those criteria under the DSM. Whereas competency evaluations, I'm not there to make a diagnosis. I'm there to look at the individual's functioning.
Now, you compared that to social security disability. So would I be correct in saying that it doesn't necessarily qualify them for benefits? Is that where you were going?
Correct,
Okay.
yeah.
Competency different from whether someone would benefit from treatment?
There's and it depends on a lot of factors, right? If I guess the opinion on competency is not to really doesn't change the fact that somebody can have a serious mental health condition, right? Currently, I feel like I went on a tangent. It's okay, yeah. Let's see, right? So essentially what I was just talking about with those two prongs of this list. So when I'm talking to them about their case, are they based in reality? Do they have an understanding? It can be self-protective, right? It can. But I'm looking specifically for, if somebody was so distracted by voices that they might be hearing that they couldn't attend to the conversation we were having, that would be concerning, right? If the person was that was overtly delusional, right? So not based in reality, you know, that would be concerning. So I'm looking at basically, do they have a presentation? Is their clinical condition impacting their ability to sit and function as it relates to those two prongs? Can they understand what they're talking about? And are we able to have a rational and reality-based and reciprocal conversation about the case?
How did Mr. Martin's case come to you for review?
So, so cases are assigned to us, randomly. So essentially we get a schedule each week and we're given the cases that we're to see for the following week. And Mr. Martin's case was on my list of folks to see for the following week.
And what was the purpose of your March 30th, 2026 evaluation?
So the purpose of that evaluation was for one of those 90-day progress reviews. So I reviewed the finding and order on competency that you signed and reviewed the, I'm sure we're getting to that, right? But reviewed the other materials that were in his case file.
Did you form an opinion as a result of your evaluation?
I did.
And did you draft a report to explain that opinion?
I did.
Does the court need a formal motion to admit the report? I know you have a copy. So at this time, I move to admit the report.
And I was gonna say, it's her report, so I'm sure there's no objection.
For the purpose of this hearing.
Okay, so exhibit 2 will be the April 15th forensic report as authored by this witness, Ms. Delaney.
Thank you. Before we get into your specific findings, what did you understand the prior procedural posture of Mr. Martin's case to be?
So my understanding of that was that essentially Mr. Martin had been found incompetent to stand trial. There was a court order signed, and that he was still in that, I guess, pre-trial phase, right? They're still waiting to enter a plea. I don't know if I'm answering your question.
When the defense challenges the scope of her expertise, for example, whether her social work degree alone qualifies her, they are essentially challenging the foundation of her testimony. The court must accept that the evidence presented meets the necessary standard of scientific reliability to be considered admissible.
Had he been seen before in this case or in other cases?
Yes. So, after reviewing records, I noticed that he had a prior referrals with the forensic center. He was seen on one prior occasion for a separate legal matter by a forensic center examiner. He was seen for this case on one prior occasion by a forensic center examiner, and then I also saw that there was another evaluation performed by an independent examiner.
In that prior case that you mentioned, was he ultimately adjudged as competent?
In the first case, in a
Yes.
separate legal matter, he was deemed competent to stand trial by that evaluator.
What information did you review before you formed your opinion?
So I'm looking at, there were a few pieces of information that I looked at, right? So one of the things I'm looking at when I'm evaluating somebody is their clinical interview, right? So I based my opinion heavily on that clinical interview because that tells me how that person is doing in the here and now, right? And then I also looked at the prior reports that had been submitted for him.
Did you review any police documents
Yes.
or other court documents?
So I reviewed the reporters as well, and I reviewed the police version of the alleged events.
And then you said you reviewed the reports provided by Dr. Ford,
Correct, yeah.
and there were two of those, right?
I only saw one report from Dr. Ford. So the reports that I reviewed ahead of time, or as a part of my evaluation, I guess, just in learning all of the information, right? There was a report by Ellen Garber, psychologist, that was from 2021 for the separate legal matter. And then there was a report, I believe dated April 2025 from Glenn Toplin, also psychologist with forensics, and then Dr. Ford's report.
So the second Dr. Ford report was after you formed your opinion, right?
Okay.
So how long did your own clinical interview with Mr. Martin last?
Approximately 55 minutes.
And what topics did you cover in that interview?
So in that interview, I asked about I obtained a little bit of information about his historical kind of personal background, right, as part of that evaluation. And then we discussed his case and the court process in general.
So how do you use records, interview behavior, and the questioning together when you're forming your opinion?
So I'm looking at all of those are data points to me, right? So when I'm forming my opinion, I'm looking at all of those things. And I mean, yeah, I'm looking at all of those things when I'm forming an opinion, right? So the history is important, right? Because like, I mentioned earlier, right, it's important to acknowledge if somebody has had a history of mental health symptoms, right? Or a mental health diagnosis. And I'm really wanting to look at that current functioning.
What would you have looked for if Mr. Martin were unable to understand the proceedings or assist rationally?
So I guess when I'm looking at somebody doing a 90-day progress report, what is one of the things that's important for me to understand prior to, or even when I'm meeting with them, or as I'm forming my opinion? When I'm looking at the report, in this case, Dr. Ford's report, right, of the evaluation that deemed him to be incompetent to stand trial. I'm looking for what were those initial barriers impeding competency that Dr. Ford pointed out, right? And then when I'm thinking about, my clinical interview, I'm looking at, especially because this is somebody who's already been deemed incompetent to stand trial, right? Competency, have those been resolved, right? or maybe perhaps I'm seeing something different. So that was, yeah, one of the factors that I considered.
Before the interview began, did you tell Mr. Martin about the purpose of the evaluation and explain confidentiality?
Yes, so yeah, we reviewed, there's an advisement form that we utilize frequently in evaluations, and that, we would be talking about this case. I reminded him or informed him that, there were limits to confidentiality, right? We wouldn't be releasing his information to the general public. However, there would be things that I could potentially have to come here and testify, and that I would also be writing a report that would be going to, the judge, the defense attorney, and the prosecutor.
How did Mr. Martin respond to that advisement, and what did you observe about his ability to understand at that point?
So my observations, he didn't have any questions that I can specifically recall, but he indicated that he understood, and, had an opportunity to ask questions. There was nothing concerning that suggested to me that he didn't understand those items. Also, I'm sorry, am I able to look at my report as we're discussing it? Is that okay?
Yeah.
I have a copy of it. Is that all right?
Yeah, if you need to refresh your memory on something, sure.
Do you need a moment to look at it now? Or would you-
No, I just like to have it.
Okay.
Okay.
It's been admitted as evidence, so you can.
Okay, thank you. I just reference really long.
Would you please describe Mr. Martin's cooperation from the time he arrived until the end of the interview?
Sure. So, with me, he was very cooperative, right? There were no behavioral issues, right? We sat down, we had a good conversation. I didn't have, as part of that advisement, I always inform defendants that they have a right to skip questions if they would like to skip questions. To what I recall, I don't think he skipped any questions. He was cooperative. He's a really nice guy throughout. I also checked in with the staff at the security desk. The staff at the security desk at Forensic Center also informed me that he had been cooperative that morning with like standard intake procedures. So getting his picture taken, just being assigned a room, things like that. He was a really nice guy.
Please describe for the judge Mr. Martin's appearance, hygiene, and grooming when you saw him.
So I didn't have any concerns about those items. Those are points that I'll mention when looking at somebody's clinical condition, right? But for Mr. Martin, I didn't have any concerns. He was well groomed. His appearance was neat. There were no issues, no obvious issues with like hygiene or anything like that. Eye contact was good.
What about motor behavior?
There was no unusual motor activity. So sometimes we'll be looking for things, or I'll be looking for things like bizarre tics, or like indications that they could be distracted by something. So we may see somebody looking over to the side, or tremors, or just odd gait, anything like that. And I didn't observe anything like that with Mr. Martin.
What did you observe about whether he appeared distracted or preoccupied?
He was a tenant. So like I said, we spoke for about 55 minutes. He was attentive throughout the interview. I didn't notice, there was nothing that I picked up on that suggested that he was distracted or unable to follow the full conversation.
What was his mood like?
He presented with depressed mood.
What does that mean?
So his mood was low. He indicated, feeling some stress regarding some financial matters, some job loss, and he just appeared low, like a little down.
What he described to you regarding the financial matters or the job loss in your training and experience and general life experience, would that generally cause someone to be a little depressed?
I would. That could be a stressor. That could stress, I think most people out.
So that was, I guess, for lack of a better word, like normal behavior.
Well, I mean, I wouldn't even want to slap a label on it, like normal or not normal, but I think when I'm looking at it again, did it rise to the level of impeding his functioning? And in my opinion, it did not. He appeared to be in somewhat of a low mood, but he wasn't in such a depressed mood that he was unable to respond to my questions or was so tearful that we couldn't get through the interview or anything like that. So when I'm looking at like depression as a symptom or as a marker for competency, right, I would be looking at that level of functioning that it's impeding or not impeding.
What did you observe about his orientation to person, time, and place?
So he knew where he was, he knew who he was. I remember, I think it was his birthday a few days before that. So we talked about that. He mentioned relevant people in his life in a reality-based manner. So he was appropriately oriented.
And did he discuss any other recent life events with you?
I remember he had explained his housing arrangement. I think it, he's living, I think he was living at home. I know he had come to the appointment with mom. We talked about that. We talked about, he was living at home. I remember him talking about, not really sleeping that well lately, that he had been choosing to sleep in like enough privacy, I guess, at home, or he wasn't able to sleep in the house. So we talked about just different things going on with his life around his job loss. And I remember him talking about his plans to essentially to follow up with like unemployment income from job loss.
How would you describe the organization and content of his thoughts and thought process?
So he spoke in a linear manner, right? Being organized, which is important. So for somebody who may be experiencing significant psychiatric dysfunction, they may not be able to clearly communicate. I didn't get that impression about relevant subject matter. So if I asked him a question, the answer that I received was relevant to the question posed and based in reality. It was and presented in a linear and organized manner. I don't know how else to describe that.
What did you observe regarding delusions, hallucinations, or perceptual disturbances?
Right. So in terms of delusions or delusional thinking, there was no thought content that was expressed that I observed from Mr. Martin that day that I would have classified as being overtly delusional, right? So the topics that we discussed were based in reality, and there was nothing to suggest that he was hyper-focused or even focused. He didn't mention any at all, that I can recall. So I didn't notice any delusional thought content on the day of the evaluation. In terms of perceptual disturbances, when I'm referring to perceptual disturbances, I'm referring to the different types of hallucinations that a person can experience, right? So looking at like the five senses. So are they having auditory or visual hallucinations? Are they having tactile hallucinations or any other hallucinations that they may be reporting? He didn't report any that were going on at the time. And also based on his mannerisms and behavior during the evaluation, I didn't get the impression that he was distracted by them at that time either. I didn't notice any. So some things I might be looking for would be, somebody answering unrelated questions or giving like those behavioral indications, like I mentioned earlier, right? Like looking over to the side, somebody maybe whispering to themselves, wincing. Sometimes you could also see somebody who's distracted by internal stimuli might also exhibit what we call thought blocking. So having like a long period at random bizarre intervals, so kind of stopping mid-statement.
And no issues with that?
No issues with that.
Okay. Did you observe anything about his memory for recent or remote events that played into your opinion?
Sure. So what I observed about recent and remote memory is that it appeared intact. He provided relevant information about his recent and remote history.
And so what did this appraisal suggest, all of these that you've just discussed so far, about his intellectual functioning for purposes of the legal issue before the court?
So for the purpose of my evaluation and the question that I was trying to answer for the court, he was functioning at a level that allowed him to discuss his case in a relevant and reality-based manner. And there was nothing that I observed during that evaluation that would have impeded his ability to function as it relates to the prongs of the statute.
Now I'd like to talk briefly about his psychiatric history. What psychiatric history did you consider in this case?
So I looked at those prior reports from the different evaluators, right? And in those reports, I noticed that he had a history of, or a prior diagnosis of schizophrenia. That was most notable, which he did acknowledge. We talked about it during his interview. He acknowledged that he had this.
When reviewing these records, the court must ensure the expert is qualified to speak on the facts presented. While the witness here describes internal protocols, the court ultimately determines admissibility based on whether the information provided is reliable enough for the jury to consider.
Prior diagnosis. And he also acknowledged that he had been prescribed some medications for the treatment of that diagnosis.
When were those medications prescribed?
He informed me that they had been prescribed in January of this year.
So January of 2026?
Yes.
What did he report about his sleep?
So he reported that sleep was not great, that he had been maybe sleeping an hour or two at night, even the night before. I think he described his sleep as being a nap and not an actual sleep.
Did he appear to you to be lethargic during your interview?
No, so yeah, so even despite of those, reported sleep disturbances, he was attentive. I didn't notice, he didn't appear overly lethargic. He was able to be attentive and alert throughout our meeting. He didn't need any breaks.
Did his report about sleep affect your opinion in any way regarding competency?
No, not in terms of competency. Again, I mean, I would assume that somebody's going to perform even better had they had the full 8 hours of sleep or, whatever they're saying we should get these days, right? So I guess in terms of competency, I would estimate that he could perform at least as well as he did on the day of the evaluation, considering the amount of sleep that he got the night before.
And so am I correct in understanding that maybe clinical concerns for something like sleep or these diagnoses, in your field, can a person have a serious psychiatric history and still be competent to stand trial?
Yes.
Could you just explain that?
Sure. So, we see this, I've seen this quite often, or I've seen this, I guess, a fair amount throughout my work at the forensic center, right? That somebody can have to meet the delusional thinking, right? As long as that delusional thinking is not when evaluating their competency. In my opinion, would not impede their competency to stand trial. And like I said, for Mr. Martin, I didn't notice any, significant like delusional thought content on that day, and no other distraction. But yeah, we may have a diagnosis and they're also functioning.
I'd like to move to Mr. Martin's understanding of the nature and object of proceedings. Would you please describe your discussion with Mr. Martin about his criminal case?
Right, so and correctly answer questions about just the court. I remember we discussed like a hypothetical example of like, remember the specific hypothetical. I don't tend to write that part down in my notes, but I did note that he chose the more favorable option when given those hypotheticals.
So it was your opinion that he understood the allegations or charges in this matter?
Yeah, not only in this matter, but I think the other, which again, if I'm using it as part of that data to inform on competency, was he again was very concerned about money, was very concerned about his employment status, right? So he voluntarily and kind of spontaneously brought up these points during his evaluation where he was talking about very specific nuances of, the process of applying for unemployment or the circumstances around the job loss and how that may impact his ability to get unemployment benefits in the future. So maybe not in the context of this specific, maybe that's not the right word for it, but demonstrate the process, like thought process around that, and could understand kind of the items that would weigh on that process as well.
Okay, so his thought process was complete and organized on that subject, and he was showing similar completeness of organization on the subject of this criminal case?
Right.
Okay. Did he understand his role as the defendant?
Yes.
Did he seem to understand, the possible consequences of the case?
Yeah.
And did he seem to understand the adversarial nature of the criminal proceedings?
Yeah.
Did he seem to understand about the roles of defense counsel and the prosecutor?
Yes, and in fact, I remember at certain points of the evaluation, he even referenced like, hey, I feel more comfortable if I talk to defense counsel about that first. So he referenced, the importance of, utilizing defense counsel and their role to help him. Yes.
And how did his understanding of all of these things compare with what you would expect for competence?
To even like agree to that word compare, right? Because I'm not comparing him necessarily with others. I'm looking at his specific functioning and abilities on that day as it relates to the statute. So in my opinion, he demonstrated his capacity to work rationally. He was rational with me. He rationally spoke about this case. He rationally spoke about other events. He rationally spoke about his personal history. And he also demonstrated his understanding of the nature and object of the proceedings.
Just give me a moment. I'm just skipping some questions because you've been so thorough. Did you observe anything that would prevent Mr. Martin from communicating with counsel in that thoughtful and organizational way like he did with you? Do you think that there would be a difference when he communicated with his counsel?
There was, nothing that I noticed or picked up on.
Did he mention any specific issues with communicating with counsel?
He did not.
Okay, and he seemed to trust his counsel.
He did.
And what, if anything, did you observe that would prevent Mr. Martin from performing the tasks reasonably necessary to assist in his defense?
There was nothing that I personally observed from that interview that would have prevented him from meeting the promise of the statute.
The prior opinions that you reviewed from Dr. Garver and Dr. Toplin inform your analysis of Mr. Martin and his functioning over time.
Right, so, okay, those are, yeah, so when I'm looking back at those other reports, I've focused on what was his clinical presentation like during those time periods, right? So were there symptoms, right? What were those symptoms? And even looking at in those reports, they had looked at his history, his psychiatric history, and some things that popped out were, they discussed periods of time when he had been symptomatic, either when he was involved in treatment, right? Or periods of time that he had been symptomatic. So what stood out to me about the time, about when he was more symptomatic, right? The symptoms that they mentioned were essentially this hyper-religiosity and preoccupation essentially with like religious and more symptoms. So those were some things that they highlighted as being symptoms that had been noted in the past for him. In terms of his presentation on the days of those evaluations, I believe Dr. Garver had noted, there are two things that I recall that she noted, because I recall that she interviewed him twice. She had mentioned that there were maybe some residual psychiatric symptoms, right? So there was perhaps some delusional thinking or some type of symptoms, but that he would be attentive and meet the promise of the statute. I also recall in Dr. Garver's report between that first and second evaluation that she did with him, he had demonstrated his ability to retain knowledge from the first evaluation. So I believe there were some legal concepts that maybe he was a bit more confused on the first evaluation that they did. And then when she met with him the second time as part of that evaluation, he had recalled some of those things.
So taking those reports at face value, was it your opinion that he had improved from that time period?
Sure. So, yeah, that would be a good way.
Now, you mentioned that you reviewed Dr. Ford's June 2025 report, correct? What, if anything, did you find significant about his testings and conclusions in that report?
Sure. So, Dr. Ford put together a really comprehensive report, that I reviewed carefully. I think the things that stood out to me when reviewing the report were, again, I'm looking at what was that? Because I'm kind of trying to think backwards, right? So Dr. Ford is the one who's saying that, Mr. Martin did not meet the statutory criteria, right? So I'm looking to see what were the barriers to competency that Dr. Ford is noting. When I read Dr. Ford's report, however, what I noticed was he essentially described an attentive individual who was, and I believe I have to look at the report, but I believe he even mentioned that he was rational in discussions. He mentioned
Did you say rational or irrational?
rational,
Okay.
rational, that he was rational when discussing his case. He described a pretty stable clinical presentation, I guess, during the time of their interview. So that stood out to me. When I was looking at what I took away from Dr. Ford's report as being that primary barrier to competency was Dr. Ford's, I guess, trying to think of a good word for this, estimation, I guess, that, there could be some variability in the future. There could potentially be variability in the future with how this person's symptoms manifest. And that to me is how I took that's what it seemed that he had based his opinion on as being that primary barrier to competency, that although Mr. Martin did well on that day, he could potentially, in the future, that could potentially change.
So he was dealing in the hypothetical.
That was my interpretation. Yes.
And how did you evaluate Dr. Ford's concern that his functioning could fluctuate? I guess if there's been any, your observation.
I guess I hesitate to say that I'm evaluating any other evaluator's work, right? Because I wasn't there that day on their evaluation, right? And I want to be respectful to the other professionals, right? And I took that into consideration. And again, my interpretation of that legal statute, how I was trained, how I became certified, my experience at the Forensic Center, both on that inpatient and outpatient side of things, my interpretation of the statute is, I guess, different, I would say. I would find it harder to justify the other way of saying, hey, there's a possibility that in the future, this could potentially look like this, right? So I'm looking more at the here and now. When I was meeting with Mr. Martin, how did he do that day? How is he able to manage, these functional capacities as they relate to competency?
Now, you mentioned earlier that you did not review Dr. Ford's May 5th, 2026 interview with the defendant, right?
No, it's the first I'm hearing about it.
Okay. I do believe it was attached to an email, but we were communicating late, so it's okay.
Yeah.
If Dr. Ford were to emphasize schizophrenia or schizoaffective symptoms.
So in my opinion, right, it's two different matters, right? So
She's asking her about some area of expertise that I don't believe she was ready to assuage or even ask that question, because she's asking about a schizophrenia diagnosis. And that's my objection.
What was the specific question again?
If the defense were to emphasize schizophrenia or schizoaffective symptoms, how should the court understand those diagnoses in relation to competency? And Your Honor has accepted Mr. Leonard as an expert in competency to stand trial assessment.
Right. And then she did comment that she is, even though that's not something that she does as far as evaluates, that she has some experience in how those different disciplines are trained to evaluate competency. So I guess you can answer that. So go ahead.
So I'm sorry, one more time for the question.
Explain to the court and to us how we should understand diagnoses of schizophrenia or schizoaffective symptoms in relation to competency.
Sure. So again, to me, those are two different areas, right? Even broken down further, right? You mentioned two different diagnoses in that statement that you just made too. So there's
Schizophrenia, schizoaffective disorder, two different things. Is that what you're saying?
They can have schizophrenia, they can have schizoaffective disorder, they can have, considering, sure, right, they're demonstrating at the time of that evaluation, what are their functional abilities at the time of that evaluation? And still function in various domains of their life.
To account for that.
Again, I would just go back to that functioning here and now when I met with any symptoms or clinical present.
Exact wording of the statute. Is that correct?
He wasn't taking them on.
I want you to look at it. Sure. I'm not trying to put you on.
Yeah.
Oh, sorry. They were just like, was in high school, graduated this weekend, so I didn't.
The expert is demonstrating the practical application of mental state evaluations, moving beyond simple diagnoses to assess functional capacity. This focus aligns with the standard that a defendant must have a rational and factual understanding of the proceedings to be found competent as required in legal procedure. This line highlights the crucial difference between a medical label and legal competence. The law doesn't require perfection. It requires the functional ability to participate in one's defense, which is the core standard established in cases governing competency hearings.
Have you ever gotten from Old Street? Yeah.
Yes, I got someone. Well, you come up here.
Okay.
Sir? No. Okay. Okay. From distance. All right. Thank you.
The expert is emphasizing that competency is a snapshot in time, not a prediction of the future. This means that while past symptoms are relevant, the focus must remain on the defendant's ability to function rationally right now, aligning with the functional requirements set forth in the relevant statute.
Yes, we. Like I said, I got a mobile. I'm sure. Inserting. Set up to one new leader. Do you need another one?
No, okay, thank you.
So we were supposed to have Lucian Hudson on the docket today too, I thought. For the verdict on the. Did I understand that incorrectly?
No, okay. Let's see it on my sheet.
June 2nd. The problem is that it's not on any date in JIS, and I wrote down June 2nd from the last hearing. So maybe Jessica could check on that,
Yeah, I have nothing bad.
although I don't see, wasn't council, so I could be wrong. Yeah.
She comes back.
All right, dear.
But I don't feel much.
Yeah. I don't get my work from home day today, so.
Comes up with them. When she comes
Okay.
back.
Because there's just specifics, but like, you're not supposed to get my key test. No. Like you're only supposed to get so. Things like the bonus taxes, and this. The one that was there.
Okay, all rise. Mr. Court is back in session. Honorable Sheila R. Johnson presiding.
All right, may be seated. Did we get her a copy of this? Does she?
She has a.
Go 237 FY. At the break, we adjourned so to see it before, but did you have at least some general opportunity to familiarize yourself? So, I think you were still questioning at the time.
Did you find it to be reliable? You know, there, I don't know how to answer that.
As far as reliable, I mean, the word reliable, there.
Yeah, what do you mean by that? Let's spell it out.
I guess I'll ask the question at the end. I'd like to go through the report. You have it there in front of you? Yes. Okay. Would you please walk us through the portions of the report, if anything, that you found notable? Sure. So I think the things that stood out to me on this initial review, so just a few things, right? So I'm looking at the description of the clinical presentation during this most recent evaluation by Dr. Ford, right? So what page are you on and referencing now? Sure. So on the first page here, there's a section titled Brief Case Overview. I noted here that it says that Mr. Martin reported that he was stopped by the Southfield, Michigan police while driving. He was arrested and charged, and then it continues on, right? To me, as I'm looking at that, I'm thinking, okay, well, if Mr. Martin is the one who reported this, that tells me that he at least had some knowledge of, you know, the, of what his charges are, right? So he's, if I'm taking this at face value. Okay. Okay. So then the other things that stood out, again, just in this overview, I'm looking, and this, some of this information I have from my evaluation as well, but just the, his background information, right? For example, and that's on page 2. On page 2, right, under brief personal background, there's an educational history that's listed, you know, noting Mr. Martin as, having made good grades in school. Mr. Martin and I also we're alumni of the same university, the Eagles, right? Alumni of Eastern Michigan University. And I noticed that he was a student there for 2 years studying biology. You know, so again, it's just telling me about his ability to report on information and just a little bit about his educational background. The other thing that I'm noting on that same page, same section under brief personal background, under brief legal history, I'm seeing that Mr. Martin took a plea in court for a prior legal case, right? So that tells me, you know, presumably there was some legal knowledge and understanding at that time. And then it also mentions some of the psychiatric history in that section as well. I did find it interesting under psychiatric history, under that brief personal background section where it says psychiatric history. It says that he's been receiving psychotherapy from Dr. Barlow to address issues associated with competency, trauma, and coping skills. I would, I guess, want to know more about that. What competency treatment is he receiving? And what would that look like? Other things that stood out, just as I'm going through this on the first page under mental orientation, where Dr. Ford is talking about the mini mental status exam that he completed. In that paragraph under mental orientation, he describes Mr. Martin as performing in the normal range and being able to you know, to score within the normal range of that test. So that speaks to his functional capacity during that time period. There was note of the prior intellect testing that was also performed, I believe, at Dr. Ford's initial evaluation with Mr. Martin. I'm still on page 3, but just looking at those WASTE results with the Wessler Adult Intelligence Scale, he just highlights those again, which, and I'm sure Dr. Ford will talk more about this, but you know, it places Mr. Martin, his full scale IQ is placed within the normal range, right, as a score of 91. So that stood out to me as well. And then moving forward, page 5, I see that there was some testing done for placing Mr. Martin in a range of having mild anxiety. Page 6, the way that Mr. Martin had been experiencing some severe depression, as it was categorized by Dr. Ford, which aligned with the scores that he received on this test, right?
And so how would the findings of anxiety and depression relate to competency?
So it's interesting, just as a total picture of somebody's mental health, but as it relates to competency, if I'm looking at that and then relating it back to functional capacity, those are two different things, right? So many people have mental health conditions, many people's mental health conditions may be in a variety of severity. But again, that doesn't necessarily automatically equate to a specific level of functioning. The thing that stuck out to me on this page as well, on page 6, under the Yale University Crime Screening Test, Dr. Ford mentioned that it says Mr. Martin denied having present auditory or visual hallucination, but his thinking was disorganized and delusional and illogical at times. I guess I'm curious to know more about that, right? Because it doesn't. I would be curious to know more about that. And again, how did it impact the functioning during this specific evaluation? Because, and I'm not a psychologist, I don't administer psychological testing, but in my years at the Forensic Center, doing psychological testing consults with senior staff, there is a certain level, depending on the test, right? There is a certain level of functional capacity that an individual must possess in order to reliably complete some of these measures, right? So when I'm looking at like other scores, like his ILK scores, for example, at the bottom of page 6, top of page 7, it's noted that Mr. Martin did reasonably well on this testing measure, scored 49 out of 60 questions of legal knowledge. So going back to that statement on page 6, under that Yale University section, where he's noted to have disorganized and delusional and illogical thinking, again, I'm kind of questioning, right, if that is the case, right, and assuming that is the case, again, to what level does that rise to impairing his functional ability, right? Because he was functional enough to then perform very well on this mini mental status, to perform very well on this ILK test that was done, so that there's some inconsistency, I guess, with the performance.
So you're saying, I'm sorry, inconsistency with what?
With I guess performance in terms of its functional abilities, right?
As described in this report?
Right, yeah. The other thing that stood out to me just on the last page under the conclusion, and again, I'm just taking this at face value, but what does it say here? So one thing that stood out to me, there's a phrase here about halfway through the conclusion, right? So it says that there were cognitive distortions that he observed, right? And he described these as habitual, inaccurate, and typically negative thinking patterns that seem to skew Mr. Martin's perception of reality.
What page is that on?
Page 7 under conclusion, about halfway down.
Okay.
And let me just 1, 2, 3. That's on about 11 lines down there.
So it starts with, where the sentence that starts with this writer interviewed Mr. Martin on 5/5/25, and so is he mentioning the 25? Is this the 25?
Yeah, he was mentioning the 25 interview. I'm not sure how that relates to where we are in 2026, but that's what he mentioned.
So I don't know if there was an inaccuracy, maybe, but the date, I don't want to say that, but the thing I guess that stood out was this mention of cognitive distortions, which in the mental health field, to me, cognitive distortion and symptoms of psychosis, those are two very different concepts. So cognitive distortions to me is it's this description of automatic thinking patterns that many individuals possess. I'm sure that many of us in this room probably possess these things, and these are—
Can you give a couple examples?
Sure. So these are examples like where a person may tend to catastrophize everyday events, or a person may tend to overgeneralize and have all or nothing thinking or black and white thinking about things. Kind of things always go right for me or things always go wrong for me. And this is something that we see that I've seen in the mental health field with folks who have depression and anxiety. And
So your testimony, if I'm understanding correctly, is maybe somebody who is depressed might have the mindset that everything just always goes bad for me, no matter what I do, it's just always going to
in
be.
fact, capacity or to competency and functioning is that having a mindset where things never work out for you, right, is very different than having psychotic beliefs that are impacting your defense strategy, right? So if it's very different than believing that, you know, instead of waking up as a social worker today, I woke up and I said, hey, I've been a part of the FBI for the last, 58 years, right? That would be irrational in a lot of different ways, right?
So that would be more delusion that would affect competency.
Exactly, right? But cognitive distortions, to me, again, taking that phrase just at face value, that is more, to me, that's more a descriptor of a thinking pattern that can impact somebody's negative mood, I guess, or outlook of themselves.
And that would be fairly common in the population.
It's pretty common, yeah.
Okay. And then have you interviewed or evaluated defendants that do have these delusions, like they work for the FBI? Okay, and how regular is that?
I mean, I see it quite a bit, right? There's different delusions, right? Then delusions can be based on a lot of different things, right? And that could be a whole afternoon, but I don't think we want to do that.
Okay, and you didn't, just to be clear, you didn't notice any of that or observe any of that sort of behavior with Mr. Martin?
No, and specifically looking at Mr. Martin's history that was noted in some of these other reports, right? In stating that when symptomatic, when he is delusional, he tends to go more towards like hyper-religious state where he's very preoccupied with religion. And those are the things that are really informing his delusions when he is delusional. Again, these are very individually based, right? I didn't get any impression of that when I met with him. I don't think religion came up at all. He was able to focus on the questions that were asked in a rational way.
But could someone, for example, with very strong like religious thoughts and statements still be competent?
They could, yeah. But again, it's just how much does that impact your case, right? Lots of people are religious. They have varying degrees of how much that impacts their life, right? It would only rise to a level of concern if it was, conflicting with other collateral information, or there was no flexibility in the thinking pattern of, what if it was presented this way or this way, right? There's no flexibility in the thinking pattern. That's what the delusion of being is done. Okay.
Now you mentioned previously that you have trained approximately 20 individuals to be evaluators, right? Have you also given trainings or advice on report writing?
Yes.
What would you say, I guess, would be where this report is strong or falls short?
I think I would, I could use some more behavioral examples, I guess, that would be helpful. Again, I'm just very hesitant to comment on another, evaluator's report writing abilities. I am noticing some, small grammatical things in here, right? That's not really a be all and end all. But again, if I'm looking at somebody's forensic report writing, again, I want them to go back to that functioning question, right? So it's great that we've gathered all of this information. And how does all of this information inform that opinion? So how are we connecting A to B in terms of how it answers the question before the court? So while all of these measures, were administered and, scores were obtained, that's great information to have about an individual in general, right? And how does that
When medical diagnoses like schizophrenia are discussed in competency hearings, the law requires us to look at function, not just labels. The court must assess if the person can meet the statutory requirements of understanding their situation, as opposed to just having a specific diagnosis.
impact competency and functioning. How did that come up? Yeah.
So if you were to take the findings of Dr. Ford at face value as listed in this report, and you've noted that there aren't too many specific examples, do you believe that his conclusion is supported by what he observed as listed in his report?
I'm noticing some inconsistencies with the ability to, it seems that he performed very well at some of these measures, and if the functioning was so.
The initial exchange shows the day-to-day administrative realities of the courtroom, where scheduling conflicts and clerical errors can stall a complex proceeding. Even in critical mental health hearings, the legal process is heavily reliant on meticulous record-keeping, which is why accurate docket management is so vital to ensuring due process for every defendant.
So impaired at the time. I guess my question would be, how were we then able to perform so well at these measures if symptoms were so significant at that time that, they were impeding functioning? That was the main inconsistency, I guess, I would want to know more about.
Okay. And then how would you respond to an argument that Dr. Ford is a doctor and
This exchange perfectly illustrates the core judicial challenge, translating complex clinical data into a legal finding. The court must bridge the gap between a diagnosis, like depression, and a legal standard, which demands evidence of impaired functional capacity, rather than just the presence of a condition.
a clinical forensic neuropsychologist, according to this report.
Than the other, right? It's just different. So my interpretation of the statute as it applies to the case, as I've mentioned many times today, is that Mr. Martin's functioning at the time that I evaluated him. And
The expert witness is navigating the high bar set by the law for determining competency, which requires more than just a lack of stable mood. The standard, rooted in principles similar to those guiding effective assistance of counsel, demands that the defendant both understands the charges and can rationally assist their lawyer. This is a complex legal threshold, not just a medical opinion.
is that Mr. Martin's functioning at the time that I evaluated him. And really across the board, what I was attempting to start to say earlier, right, was if I'm looking at the totality of all of this is my firsthand experience, but then I'm looking at the two Dr. Ford reports, if I'm looking at each one of these interactions with Mr. Martin, generally able to answer questions about the case, that was Dr. Garber, there were some residual psychotic symptoms, right? But even then, the overall clinical presentation, not the opinion section, right? A fairly stable clinical presentation, right? So, and even in Dr.
However you word it.
Fairly stable clinical, yeah, because the other thing is too, even in this May 5th report, right? He's saying that, he knew about his charges, right? We can gather from this report that he did well on this mental status exam. He was at least able to participate in these various measures that were administered. And then on his prior report, that initial report on competency that he did, Dr. Ford did back in June of 25, there were even measures utilized in that report where he describes a very stable clinical presentation, even as it relates to competency. And I don't know if I would be able to do this, but if I can refer to a part of that report that stuck out to me. Sure. So in Dr. Ford's report dated June 3rd of 25, on page 6, probably, I don't know, it's in this top paragraph here, right? Kind of towards the end of this first top chapter, there's a sentence that kind of starts to give us this testing that he's describing in this top paragraph was an evaluation of competency to stand trial revised. It's a psychological testing measure that Dr. Ford goes in to explain, how it works and the scales used and all of that, right? And that's his area of expertise. I will say that. And what I'll also say is, as someone who is in contact with reality, all of Mr. Martin's scores on competency scales are within the normal range, indicating that he can consult with his counsel and have a factual understanding of the charges, and also has the ability to rational understanding of the courtroom. So
Taking that statement at face value with the statute for competency, how does it compare?
I mean, to me, that statement at face value, if I'm looking at the statute of competency, I'm thinking that sounds like a guy who's meeting the prongs of the statute.
So just to wrap everything up here. After considering the records, your interview with Mr. Martin, his clinical presentation, all of the answers to the questions that you asked him, what is your opinion about Mr. Martin's competency status?
So it's my opinion that at the time that I interviewed him and considering all of this information, it's my opinion that he's competent to stand trial. If I'm looking at that statute, right, the legal statute stating that, you know, somebody has to be able to understand that if you're not there through the proceedings and is able to wrap in assist, I think that someone who needs to speak to those topics.
And now we've had a couple hours of testimony and you've given us so much information, but what are the most important facts just that that support your opinion?
So supporting my opinion would be a stable clinical presentation, thought content that was expressed, our conversation went, employment and everything.
Does his current mental condition prevent him from understanding the nature and object of proceedings in your opinion? An opportunity to observe Mr. Martin as he sits here today?
Yeah.
And as he presents today, is it consistent with how he was when you met with him?
Yeah, I mean, again, we're not talking, right? But I've again, over here, and I'm not here specifically for an evaluation, but have I overtly noticed any concerning behavior? No.
Have you observed Mr. Martin to have spoken with his attorney throughout the course of this hearing today?
It seems like they're sharing some information back and forth.
Of course. And does he appear to you to be well-dressed and groomed appropriately?
Sure, yeah.
Anything concerning at all that you've observed about?
After sitting here in court for a couple of hours, you know, it's been calm, collected, right?
Happen going forward, what would that look like?
Right, so my understanding is that when there's been a finding and order on competency that's been signed, right, what that does is on his, on the wait list and his current placement, which I admittedly from Security Psychiatric Hospital.
Is it your opinion that he needs inpatient treatment? And
How long the treatment would last?
If somebody is admitted after being found incompetent to stand trial, I can't myself comment on, right? But what I will say is that having worked on the admission unit and work competency related matters, they're going to start doing competency assessments, either formally or informally. Or the type of overall treatment for somebody who, you know, has had the bad luck of getting a diagnosis like schizophrenia, right? It's not like that for competency restoration treatment. The treatment at CFP then would just look process, right? So I can't comment on the amount of time, but I will say that the admitting unit would essentially just be going. They do their hearing, you know, they're deemed competent. Back in jail, whatever that opportunity. Compensate, right? With or without treatment. You know, we do our best to.
The expert testimony strongly favored Mr. Martin's current capacity to stand trial, contrasting with one of the prior expert reports. The court ultimately weighed the immediate observable functional ability against the possibility of future symptom fluctuation. The ruling confirms that current, demonstrated capacity is the critical benchmark in these legal proceedings. Based on the expert's testimony regarding Mr. Martin's stable clinical presentation and positive competency scores, the court concludes that he meets the legal standard for competency to stand trial. While the expert noted uncertainty about long-term treatment needs, the immediate legal finding is that Mr. Martin is capable of participating in the judicial process. The court will now proceed with the case under the assumption of competency, moving past the initial evaluation phase. This hearing illustrates the tension between clinical diagnosis and legal capacity. While mental health conditions are important context, the legal system ultimately demands evidence that the defendant can actively participate in their own defense. Always remember that the law prioritizes current functionality over past medical history. Watch next week as we see how the judge applies this standard to reach a final decision. The testimony reveals a vital distinction in forensic psychology. Cognitive distortions, common in anxiety or depression, are not the same as delusions, which directly undermine legal competency. The law demands proof that a defendant cannot understand the proceedings or assist their attorney, a standard far higher than merely having negative thought patterns. Watch next week as we see how the judge applies this standard to reach a final decision. Competency hearings are not about determining if someone is well or stable. They are strictly about whether the defendant can participate in their own defense. The law requires proof of functional understanding, not just the absence of severe symptoms. That is the critical line separating medical observation from legal determination. Subscribe now to follow how these legal findings shape the rest of this case.